Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Sara Burns explains Uber's agreements with its drivers. So, let's tear it down. Sara Burns, welcome to the Contract Teardown Show. How are you today?
I'm great, Mike. How are you?
Pretty good. We're getting into some nerdiness, as we often do. I'm going to share this document with y'all watching. This is a software license and online services agreement dealing with Uber and the transportation company. We'll talk about what that means exactly. But before we do, Sara, what is this document? When are we going to run into this kind of thing?
Well, this is a document between Uber and its drivers. People will run into this or something very similar to this if they download the Uber app and decide they want to be a driver. These are the terms a driver would have to agree to before they could start picking up fares.
And there's a lot of fun stuff about independent contractors in this document. And obviously in 2022, and everybody's working virtually, the independent contractor space has exploded. So there's a bunch of interesting issues in here that if you're using independent contractors, you better pay attention to. So we'll dig into that. But before we do, Sara, tell us about you. What's your background? How do you come to documents like this in your work?
Sure. I am an attorney practicing here in Boston, Massachusetts. I do some work related to contracts, most often drafting settlement agreements. I've also litigated some cases involving contracts when drafters made some horrific mistakes, and then it ended up going to court and in front of a jury. So that's how I approach things when I think of what's in a contract.
Awesome. Well, we're going to dig into this one. And again, I think it's really illustrative of this sort of tangle, A, with what the heck Uber is as a company, and B, what the heck an independent contractor is. It's an interesting context. So let's start with the beginning, the introduction. As I mentioned, it's got this is between Uber and transportation company, or you, which I think is a funny framing of who we're talking to. But it's got some definitions in here of how Uber sees itself as well. Talk to us about this introduction and what you see about the relationship just starting off, how it starts to introduce what we're doing here in this document.
Sure. So Uber frames itself as a software company, which most people, especially those who take an Uber or drive for Uber, maybe don't think of Uber as that. They think of it as sort of an alternative taxi service. And it also frames the drivers as you said, independent transportation companies, which when I don't know about you, but if I jump into an Uber, I don't think of the person driving as an independent company. I think of it, that person as someone who's downloaded the app and is about to give me a ride.
We literally call them the Uber driver. We don't call them transportation company driver. We call them the Uber driver. Yeah, I was reading a book, I think it was The Fuzzy and the Techie, that talked about this issue of, in a positive way, it was like, hey, Uber is not a taxi company, it's a software company. But to your point, legally, not as clear. So let's dig into that. Sure. In section 7, jumping down, it talks about the relationship between the driver and the company. It says the relationship between the parties is solely that of independent contracting parties. You see this a lot in independent contractor agreements. What's the effect of stating it this explicitly and as it goes in to section 7?
It has some legal effect. Courts will look at this if there's ever an issue of whether someone was actually an independent contractor. But just like in the introduction here, it's always going to be looking to the substance or over the form. Excuse me. So Uber can say they're a software company, but if they're actually a ride-sharing company or a taxi service company, that's what they are. If their if their drivers are actually employees and not independent contractors, courts will handle that accordingly. From a drafting perspective, if you have someone you're entering a contract with who's actually an independent contractor, it's very important to specify that. The other thing that you should do, which Uber didn't do here, is discuss when and how that independent contractor is responsible for taxes. And so what I mean by that is most independent contractors receive 1099s by the entity they've contracted with, that entity. So here Uber isn't withholding any taxes. A good contract for independent contractors is going to specify that. In this contract, if you jump back up to section 3.5, Uber mentions a little bit, the transportation company agrees to obey laws, including taxes, but it doesn't really spell out what that would mean for a driver. And when you have an average Uber driver who maybe doesn't know too much about what it means to be an independent contractor, maybe has never filed taxes using a 1099 and understands how the additional self-employment taxes work, it's really important to spell that out. Even if it doesn't change Uber's legal obligations, it will keep drivers happy because later on they won't be caught off guard. It's good for business.
Yeah, it seems like, as a drafting activity, it seems smart to say, hey, you're an independent contractor. If nothing else, just to signal your intentions, and hopefully that starts a conversation. But to your point, a court is going to look at this and dig a little deeper and see what the relative party is or power is of the parties. So speaking of, I'm going to jump down to 12 to the modifications. And when you look at what Section 12 does, it really seems to set up somebody's in power and somebody's not. Talk to us about the modification section.
Sure. So this modification section is what's called the option to unilaterally modify the contract. What that means is Uber has said, we can change the terms of this agreement anytime we want. If you're a drafter and you represent a company like Uber, it may seem like a handy clause to have. The issue, though, becomes what does your client actually want to do with that modification agreement? Because that won't always be enforceable. When we think of contracts and we think of modifications, and if you're an attorney, you think back to law school or the bar, you learn that you can't modify a contract without consideration. Generally, that's true. A unilateral modification clause like this oftentimes is enforceable, but it depends what's being changed. If you're changing how someone's compensated unilaterally, probably won't be enforceable. The other issue to think about that Uber didn't spell out here is if there is a modification, how are you going to share that information with the other party? When are you going to share that information with the other party? From a drafting perspective, what you want to do is ask your client what they want to achieve, and then always think about, okay, if my client did that and we had this clause, would it violate the covenant of good faith and fair dealing? If you're following that, you should be good, but always exercise caution. Don't think you can just slap a unilateral modification term into a contract and then you can do whatever you want.
Yeah, jumping to 14.1, we had talked about this in advance. There's a severability clause sort of snuck into Section 14.1 under governing law. Talk to us about 14.1 and this issue of severability in contract drafting.
Sure. So severability clauses are great. They should be in any contract, not just an independent contractor agreement. What it does is it means that if a court were to say, this particular clause, and since we were just talking about modifications, we'll use that. If a court said, no, Uber, you can't modify contracts unilaterally, it leaves the rest of the contract intact. And so that's invaluable for drafters. It's one sentence, and it saves you a bunch of headache if a portion of your contract is later struck. And this actually has played to Uber's advantage because as Uber issues about employment status and arbitration, which I know we'll get to, get litigated in court, courts have ruled unfavorably to Uber on certain points, but have still enforced the remainder of the contract. And so that's why a modification clause really is critical.
Yeah, speaking of arbitration, you can tell when it's a modern independent contractor agreement because there's a lot about arbitration. In this case, 14.3 is the arbitration section, and it is 3 pages out of a 10-page document. It seems like something they care about. Meanwhile, Uber has explicitly stated their strategy legally was just to go break things and then go through litigation, try to clean things up afterwards. But here we are working really hard to make it so we don't actually have to go to court. What do you think about 14.3 in the arbitration section?
It's a well-drafted arbitration agreement. If you are drafting something where your client is interested in arbitrating issues over going to court, look at this document. The thing that it does really well that's really interesting is it has an opt-out provision for the arbitration agreement. And what I mean by that is this whole document appears as a user agreement, just like some software license would, where you scroll to the bottom and you click accept. That's different from a lot of traditional contract negotiations where drafts go back and forth, both parties review it, propose changes, and ultimately agree. Here, the arbitration agreement, all the other provisions we've talked about today are set in stone in advance. But what the arbitration provision has is it has an opt-out clause that essentially tells drivers, if you don't want to arbitrate within 30 days of pushing that button at the bottom, send us a letter to this address stating as such, and you won't be forced into arbitration. And so it really covers Uber from later on having a court say, well, that was unfair. You shouldn't have done that to drivers to just make them all arbitrate like that. It covers Uber. And also, if a driver isn't carefully reading this contract, they may not even realize they can opt out. If a driver is carefully reading and, they get busy, they don't get the letter in the mail, suddenly they can no longer opt out. So it's a really strong clause, not just in its level of detail, but it's sort of a challenge for a driver who doesn't want to arbitrate if they didn't manage to opt out. How are they going to manage to file something in court and get in front of a judge and jury? The answer is they're probably not going to be able to do that.
Yeah, if Long wins, this one wins. They definitely do a really good job of going through every detail. We've talked about contracts in the past where they mention in blocks at the beginning the arbitration clause, hey, look down to the bottom. And so I think maybe to revisit that contract we had talked about previously, maybe in the very beginning I would say, hey, bro, look at the bottom. Don't miss this. But thinking big picture, it almost seems like Uber wants people to miss this. Uber has said that they want to litigate these big questions, but also they're trying to hide the litigation. Here's the thing that's interesting to me as we think big picture. I was reading the book called The Quick Start Problem by Andrew Chen, and he was a driver recruiter, over the big recruiting efforts for drivers at Uber. And he very explicitly says, man, we were trying to get every minute of these people's lives. And so thinking about the economy and where we're going, an independent contractor agreement is like me and you, frankly. You come in, you've got your own company, you got your own firm, you come in and you do a quick job. We have a temporary agreement that executes on a specific thing. You do that thing, high five, see you later. Uber very explicitly tried to get people's entire lives when they saw that people were if they were turning off the app for a short time, they were probably also driving for Lyft. And so they tried to kill that. They created incentive programs to make it so people would only take Uber drives all day. This, they're trying to look an awful lot like employees. If you are advising a company, how do you advise them to say, yes, if independent contractor was what you thought it was, that'd be a really cool option. But instead, since independent contractor is something totally agreement, instead of that, have an employee or do a joint venture agreement or do a true, really build around independent contractors. How do you advise clients through those decisions about where to get their labor force?
Well, with Uber, they have a business model that doesn't work if they don't have these independent contractor drivers. And we'll just take the phrase independent contractor out of the equation and we'll just say drivers. If they don't have drivers, their model doesn't work. Sure. Well, are they actually independent contractors then? And so if you're a business where your model depends on having a certain type of work done and done regularly, you're probably not able to hire independent contractors. A lot of states use something called the ABC test to determine if someone's an employee. And part of that test is looking at, what work does that company actually do? Is that person essential? Or like you and I here today, is someone just coming in briefly to do, one small thing for the hiring company, and then that's it, and is someone an independent professional? And then also too, where's the control? In this agreement, it explicitly says that Uber will monitor what your reviews are, and if you drop below a certain level of rating, Uber will terminate you. Is that Uber controlling the work of the driver? I mean, you could argue yes, and you could argue no, because if an independent contractor is doing a poor job, then certainly, the person who had contracted with them may terminate them. But to me, that looks a lot like control over the manner of work.
Yeah, I think in 2022, we have a lot of companies who are scrambling to figure out, how do I get a workforce in this madness, right? Like I'm excited because I don't have to have an office and have a bunch of people there. But to your point, that transition is not as simple as it sounds. You might want to look at other options for filling that labor force. Well, I appreciate you bringing this up and bringing it to us. I know that you've done some other work with us that I want you to point out because it's sort of exciting. We'll talk about your ebook, but for people who want to connect with you, make sure that you give us that information for how to reach out to us. So tell us about your ebook and how people can get in touch with you.
Yeah, so last month, an ebook came out for Law Insider called Beyond Boilerplate. I wrote it sort of with these boilerplate clauses in mind, and the focus is helping contract drafters understand what these basic clauses are, how they work, and why they're important. If someone wants to get in touch with me, I'm shy on social media, but you can reach out to me in my professional email, which is SARA@SEBURNSLAW.com.
You're not shy on social media. You're wise on social media. Well, we'll have links to all that information, including the ebook, over at lawinsider.com/resources and in the details below this video, as well as the contract. So make sure that you look there. And if you want to be a guest on the Contract Teardown Show, just email us. We are at community@lawinsider.com. We'd love to have you. In the meantime, we will see you next time. Sara, thank you and have an excellent day.
Thanks, Mike.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.